Next case set for argument is Carswell versus City of Akron, case number 29321. Both parties are present, so each of you will have 15 minutes to present your arguments to the court. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know. I'll keep track, although we have the clock on the television, which is very helpful. We have read the briefs in this matter and are prepared to proceed if you will.
Thank you, Your Honor. May it please the court and counsel, I'm attorney Mike Deffelball, and I represent the Appalachian City of Akron in this case. I would like to reserve 2 minutes for rebuttal.
Okay, thank you.
Your Honors, the issue before the court in this case is whether the trial court improperly determined that Revised Code 2744-02B1, often referred to as the automobile exception, applies to the facts alleged in the complaint. It's well established in the state of Ohio that a political subdivision's immunity is considered by a three-tiered analysis. The parties in this case agree that the City of Akron is a political subdivision and that the Akron police officers were performing a governmental function. The second tier is the issue that is what brings us here today. The trial court found that one of the exceptions under the second tier, 2744-02B1, applied in that there was an allegation in the complaint that the officer moved the vehicle. Your Honors, 2744-02B1 provides in part that political subdivisions are liable for injury and death caused by the negligent operation of any motor vehicle by their employees. There was some disagreement among the courts prior to 2009. However, the Supreme Court of Ohio in Marlington, Doe versus Marlington School District, a case that involved a sexual assault on a school bus between two students, the court found it and finally defined that negligent operation pertains only to negligence in driving or otherwise causing the motor vehicle to be moved. The court rejected the premise that was being argued by the Does that negligent supervision also constituted an exception under B1. Therefore, the school bus driver's failure to supervise the students, the Supreme Court rejected the fact that that constituted the operation of a motor vehicle. It's uncontested in this case that the police cruiser was operated at the time of the injury. There's no allegation in the complaint that can be construed as showing that the cruiser was operated at the time of the unfortunate incident. The trial court, citing Swain versus Cleveland, found that the B1 exception applies because the operation of a vehicle can encompass more than driving. That was stated in the opinion by the trial court, and cited the paragraph 70 of the complaint. Paragraph 70 states, defendant Ray pulled car number 6 with Xavier inside, he's the decedent, with Xavier inside, up closer to the residence. There's no allegation in paragraph 70 or anywhere else in the complaint that when Officer Ray moved the cruiser closer to the residence with Xavier McMullen inside, that movement of the vehicle caused his injury. The complaint is simply devoid. But if the court would bear with me for one moment, if you continue on and look at the allegations of the complaint, it bears out that there was no operation involved. For example, paragraph 76. Unfortunately, none of the named officers were with the 3 boys while they sat in police cruisers. Paragraph 80, defendant Ray joined defendant Ogo in the transportation of Allen, another suspect, leaving Chris and Xavier completely unsupervised. Paragraph 87, nearly 20 minutes after the loud pop, defendant Jaskoka and Schmiegel walked back to the cruiser. So it's clear based on these allegations that there is no operation of a motor vehicle that caused the firearm to go off while Xavier McMullen was sitting in the back seat.
Counsel,
yes.
Can I stop you for just a second?
Yes, ma'am.
I'm just wondering, as you're arguing and as I was reading the briefs, I understand what ordinarily we're talking about with the operation of a motor vehicle. But this was a unique
Unique being a police cruiser.
Right, so it's
Certainly.
not just used to transport people, it's used to transport people in custody. So it's kind of used as a temporary holding cell.
It is, it can be a temporary holding cell, sure. I mean,
So isn't that one of the purposes of its operation, to serve as a temporary holding cell?
well, Your Honor, and I think if you look at the court in Swain that the trial court cited to as support, it actually supports the city of Akron's argument and what you're alluding to for the premise that there must be some movement. The court in Swain said, in contrast to the sexual assault between the special needs student in Marlington, the conduct in the case of Barr involves an entirely different situation. And I think this is the critical sentence in Swain. The bus driver in the case of Barr, while sitting in the driver's seat and while the engine was running, declined to inspect the bus and then drove the bus away from the bus stop, even though the parent was outside screaming at the bus driver. So there still needs to be some, although it is an office, although it is a holding cell, there still has to be some support for the fact that that motor vehicle moved in causing the injury. The Supreme Court rejected a premise in Marlington that simply because there were rules and regulations on a school bus and a bus driver must, obviously keep the students under control, preclude and prevent sexual misconduct. The narrow issue before this court, that was before the Supreme Court, is whether there was any operation of the motor vehicle. So just because a police officer has rules and regulations, policies, and directives to follow, if you take it so far to the extent that because they have rules and regulations and it's a holding cell, then every single DUI that occurs in the state of Ohio would constitute the operation of a motor vehicle if that person was arrested without probable cause. So follow me for a minute. If an officer follows a car, has no reasonable articulable suspicion or probable cause to stop that motor vehicle, arrest that person, place them back in their holding cell, the cruiser, and then drives them back to the station, later finding out no probable cause, we're now back here arguing the B1 exception, which is just beyond the scope of B1 as defined in Marlington.
What injury occurred to the DUI offender?
He would be arrested as liberty deprived. Granted, he would have a Fourth Amendment analysis, but
He wouldn't have a physical injury.
he would not have a physical injury. No. Hopefully not. No. But in Miller versus Van Wert, again, it's another supervision of individuals, which I think is as close as we can get based on case law right now in the state of Ohio. The court found that there was no operation and it was a negligent supervision case in the fact that they failed to ensure that a student got off the bus. So the bus driver parked and the student remained on the bus. And the court found that there was no operation that constituted the injury to the person. And in Nicholson versus Lomax, the 7th District found that a student who stepped off a bus into a pothole, that once again there was no operation. So although it sounds technical, in splitting hairs, truly the B1 exception contemplates movement of a motor vehicle that caused injury. And make no mistake about it, the movement of a motor vehicle did not cause the gun to discharge on the decedent. Had we been here today on a failure to pat down, decedent's in the back of the cruiser, Officer Ray drives him back to the station, hits a pothole, the gun discharges, I think we have a different case. But the facts alleged in this complaint do not show that any movement of the cruiser was the cause of a physical injury. The appellee cited their brief, Groves versus Dayton Public Schools. And it's an interesting case, but I want to point out to the court, one, it was authored in 1999, before 2744 was amended in 2003, and also predates the Marlington case by the Supreme Court in 2009. But nevertheless, in Groves, the bus driver, they transported students who had to use wheelchairs. They were disabled. And in this case, the bus driver failed to put the child in and put a seatbelt on the child, harness them in, they go out and they lower them down, and the student had his arm caught. what Groves does not stand for is the premise that you're negligently supervising. The court states, we surmise that the bus designed for transporting disabled students, which goes into what Judge Carr, you were asking about, designed for disabled students, contained a ramp to lift and lower children. This would constitute operation. So therefore, there must be a component of operation and movement in the car, whether this case, as in Grove, was a ramp, that it was still operating. So I would submit to the court that even Groves versus City of Cleveland, even with the specialty designed bus for disabled students, supports the city's argument that there must be movement that causes the injury. So, Your Honors, based on Swain, Marlington, Miller, Nicholson, they all support the fact that there are no allegations in this complaint that shows that the B1 exception applies, in particular because Devin Ray, in failing to pat down, never moved the cruiser that caused the injury in this case. And I think it is that clear based on all the case law that has been surveyed on this issue. So taking all material allegations in the complaint is true, it's beyond doubt that the appellee can prove no set of facts that would deprive the city of immunity. If there are no further questions, I'll turn it over to counsel.
And you'll have 3 minutes and 55 seconds then for your rebuttal time.
Thank you.
And counsel, you'll have 15 minutes.
Thank you. May it please the court, counsel, I'm Laura Mills. I'm here on behalf of the appellee today. We are before this court prematurely, and that's clearly what the trial court held, is that at the point in time, the appellant, at the point in time that we filed the complaint and the appellant filed their motion to dismiss, we clearly had some facts, but not all of the facts. We don't know when Xavier McMullen was shot. We know that a car was in operation. We know that a car moved. We know that an individual within an operational car had injuries. We know that those injuries were approximately caused by the placement in a car that later moved, meeting all of the case law that we've just discussed. As the appellant has discussed Marlington and certainly Swain, which Swain kind of expands on Marlington to say that it goes beyond just the mere operation, because in Swain we know that was leaving a kindergartner on the bus and driving that kindergartner back to the bus garage. In this case, we have very serious allegations. We have a 17-year-old who ended up with a gunshot wound to his head, killing him while in the care and custody of a police officer who was driving the cruiser. We don't know if the gun was left in the cruiser, was sitting next to him when he got in the cruiser. We don't know if the gun was on him and there was a failure to pat down. We haven't proceeded in this case far enough, which is what the trial court was holding, to have all the facts. We merely filed our complaint. We were in the very initial stages, and in those initial stages, we met the statute. That statute is that obviously the negligent operation is functioning. The cruiser was functioning. There's no question about that. And as we take a look at Marlington, that vehicle had moved. We know that it has moved. Appellant has not argued that
When you say
the vehicle
functioning,
has moved.
what did you allege there? Were the lights on, or
It was
suppose
just-
the doors were locked?
Well, the doors would have been locked, Your Honor, but clearly the car was turned on and moved, and it was still on, is what we believe at the point in time that Xavier suffered the gunshot wound. Again, we don't know the exact timing, because what we know from the facts and what was alleged in the complaint, that the police officers said they heard a pop, but they didn't think that it was a gunshot wound. So 20 minutes later, they went out to the cruiser. We don't know. We don't know if it was 15 seconds after the cruiser was stopped. God forbid it was still when the cruiser was moving. We don't know. We haven't taken depositions. We haven't done any discovery whatsoever. We have merely met the requirements under the law to proceed forward, to get those facts, so that we can serve our client's best interest, which is clearly getting to the bottom of how a 17-year-old ends up dead in the backseat of a police cruiser. That should not happen, obviously. And so by our filing the complaint, we had a good faith belief, we had met that statute, we could proceed, we could depose the police officers and hold them accountable for their actions if during that discovery process we still meet the elements to proceed and immunity should not apply. So when the trial court wrote their order, it's fairly clearly written that it's the premature motion by the city which did not allow her to find immunity in this case because we met the very narrow, strict language of the statute. And she does rely on Swain. Swain clearly was after the Marlington case that the appellant relies on, and Swain is analogous to a certain degree in the sense that obviously it was taking the kindergartner back. It was not running the kindergartner over. The appellant seems to want to argue that somebody would have to be, laying in the middle of the road and run over by the police cruiser in order to find some type of exception. That is not the law. We do not believe that is the law. We believe we have met it certainly in our complaint and pleading it in the fashion that we did.
Well, educate me on that, because I haven't taken a detailed look at your complaint yet, but what is in your complaint? What allegations did you make in the complaint that can be construed, including reasonable inferences, that this injury was caused by the operation of the vehicle?
We do plead, starting on, Your Honor, starting really on page 12, it does state,
What paragraph would that be?
we do start a little bit earlier than that when they actually placed him in the car and the car was moved. Paragraph 67 is when Xavier was placed into the car by Defendant Ray. We indicate that Defendant Donahue, another police officer, instructed Ray to transport the suspects. We indicated that Defendant Ray pulled car 6 in paragraph 70 closer to the residence. We indicate that no one eyewitnessed any officer searching Xavier at any point in time. In paragraph 74, we indicated there was no footage. The other problematic issue in this particular case and why we need discovery is all of the other police cruisers apparently had their video cams working, and for whatever reason, mysteriously, car 6, the one in which Xavier was fatally wounded, did not have the proper recording, and it just wasn't operating that night. So we allege that in 74. We allege in 76 that none of the named officers were with the 3 boys. That's what we're being told, but again, we have not conducted discovery. We also indicate in 83 and 84 that there was this loud pop. Without being permitted to take the discovery, all we have is the police officer's statements in which they're saying that he was fine and then there was a loud pop. We don't know that. They certainly indicated they did not believe the loud pop was the gunshot wound because nobody went out to check on him when they heard the loud pop. Then when they did go out, they indicated that this gun was on his lap. And then there weren't pictures of the gun on his lap. There were other pictures of it outside, so we have no idea was the gun really on his lap. Again, this is just from the statements. We also have the gunshot wound was reported at 2308. Again, we don't know. We're not even sure that it wasn't just, like I said, provided in the backseat of the cruiser, and when Xavier got in, there was the firearm. We don't know that. We haven't been, like I said, permitted to take the discovery we feel is necessary, and we have also indicated that there are contradictory reports from the various police officers, which again, discovery would certainly be helpful in that regard. Correct, and this was the one that we argued, obviously, back and forth, was this negligent operation of a motor vehicle. I mean, we didn't indicate that they were, reckless in that regard, but obviously, for purposes of 2744, we argued the negligent operation of the motor vehicle.
Seems like the court was saying also, one of the last paragraphs, the court says, further, there were allegations throughout the complaint that the defendant's conduct was willful and reckless.
Correct.
So my point is, it looked like the court was looking at something more than automobile operation.
I think that they were indicating that clearly we had alleged that throughout the entire complaint, and we also were meeting the negligent operation of a motor vehicle exception, at least at these stages. Again, I think the entire point of the whole order was, it's just too premature, perhaps on a motion for summary judgment, once discovery is completed and all of these facts are adequately fleshed out, it may be a more proper time, but I think the trial court was correct to say that this was too early to dismiss this case. Thank you very
I
much.
don't think there's any other questions, so thank you for your argument. 3 minutes and 55 seconds left for rebuttal.
Thank you, Your Honor. May it please the court. Judge Teodosio, in following up on your question that you had for Ms. Mills, in reviewing the complaint, I have not come across an allegation whatsoever indicating that the cruiser in any way caused the injury. One thing to clear up
Well, can there be
procedurally.
it doesn't have to be an allegation, there could be an inference drawn from the pleadings.
Or an inference, and that's why we're here today, is I believe looking at the sole allegation in paragraph 70 that the trial court found persuasive. I don't even believe you can draw an inference from paragraph 70 that the automobile was moved, particularly in light of those paragraphs that I read following paragraph 70, because the whole complaint is centered around Officer Devin Ray failed to follow procedures in patting down a prisoner and placing him in a cruiser. Devin Ray failed to follow the procedures in searching the back seat of the car. There's no allegation that Officer Devin Ray was negligent when he operated a motor vehicle causing Xavier Mullen's injuries. And I think that's the specific legal point that we are here today. As far as procedurally, Ms. Mills commented to the fact that responsibility, one thing to keep in mind, this is only a motion for judgment on the pleadings as to the Akron Police Department and the City of Akron. There are defendant officers who are still in court. And I think to follow up Judge Carr, the recklessness may have been pointing to the fact of the defendant officers, but they weren't part of the motion. That case is still going to proceed. Discovery will still proceed, and the case will continue along those paths.
Of course, it's always just kind of ironic and comical to me that the city of Akron may be dismissed, but the officers are still included. It's still going to be taxpayers' dollars. It doesn't matter who you call it.
It does, but it also, as far as discovery, streamlines the case, and it's an option that's available under the civil rules, a motion for judgment on a pleading, but you are correct. We have a duty to indemnify and a duty to defend officers who are in good faith and within the scope of their employment. But I don't want to confuse the issues as if the facts in this case, we're here on a very narrow legal issue, and I know it's a tragic case. I know that. But with all that said, with that in mind, the fact is that there are more cases besides this case out there, and we have to have, as the Supreme Court argued in Marlington, or asserted in Marlington, driving or movement for the B1 exception. I submit there are no exceptions that apply in this case as to the City of Akron. Whether the officers were reckless, that's a whole different issue for a different forum. But in this case, before this court, in the review of the case law and the lack of allegations in the complaint, which is a judgment on the pleadings considers, there are no allegations that Officer Ray caused the physical injuries by his negligent operation. What's more ironic, Your Honors, as I finish up, is the fact that Devin Ray wasn't even present on scene based on the allegations of the complaint at the time of the loud pop. Devin Ray had already transported the other defendant to the police station. So to show you the absurd result that was reached below is who? I mean, there's no subject in this complaint that even with Judge Tedosio and inference, you could say operated a motor vehicle in a negligent manner. There's a complete absence of any operation by any person, but I do point out to the court that Devin Ray was not even on scene based on the allegations in the complaint.
And your time is up. So
Thank you, Your Honors.
Thank you
I ask
both
that
for
you
your-
reverse the trial court.
Thank you.
The court will take the matter under advisement and issue a decision in due course. Of course, the clerk of courts will send each of you a copy of the decision on the day it's released, and the Supreme Court of Ohio will also have it posted on their website. But I want to thank you both for your arguments today.
Thank you, Your Honor.